in the care and protection case.
If he doesn't testify?
Right.
It can be.
It can be in the care and protection case. So the court could draw an inference of unfitness if your client does not testify in the care and protection case. And so just to summarize here, okay, it looks like the department's case would be introducing Jason's statements under 23383, and possibly they're going to come in. Alicia's statements are only going to come in for a state of mind or excited utterance, but they're not going to come in for the truth. Court, again, what I just said, can draw the inference of unfitness. The investigator is going to testify, and the investigator is going to submit his report. Of course, it is all hearsay, but it's allowable. So the court, again, can rely on what the investigator has come up with. Anything else? Care and protection case?
At the very least, he did not act appropriately as a parent to what he did admit, which was...
Okay, but I'm summarizing the evidence, not your position. And guess, I didn't, because Jonathan's attorney wasn't here, we haven't mentioned Jonathan at all. So supposing that Jonathan, not only being the youngest, but not part of the alleged abuse, it still could be Jonathan's attorney's, it could be Jonathan's attorney's position that, like the GAL, possibly, that were Jonathan, old enough and mature enough to make a decision, Jonathan might want to be free from the abuse of his dad. Or Jonathan's attorney might draw a different position, that being that there are no allegations regarding him at all, that the father was, again, that would mean that father's always been appropriate with Jonathan. So again, I'm not sure what her position is.
She mentioned something the other day about Jonathan being taken away for care and protection, and she stated a case that said something like the judge said to stop a disaster from happening. Where Jonathan would get older, it could potentially happen to him too.
Okay, so she would be using her judgment, her substitute judgment approach to want to be free from Lee's abuse. Okay, all right. So that would be the department's case. Commonwealth is and the department's case, obviously, there's a problem with all of that. Will it amount to clear and convincing evidence of unfitness? Commonwealth has an even more difficult time. The 23381 has, as you guys have discussed, more requirements than 83. So that could be an either or. And so, but even if Jason's statements come in, you have really very little else. You do. The court-appointed investigator has no role in the criminal case at all. And again, Alicia's statements may come in, but again, not for the truth, but for any of the hearsay exceptions. So, does anyone want to lay anything on the table of something that could be a resolution that would satisfy, I guess, everyone in the care and protection case and/or the criminal case? Obviously, he doesn't want to go to jail, so...
Is this still as the district attorney, or is this...
As the district attorney, yeah.
And I can't see my idea. No?
No. Laura?
I would say to follow the actual investigator's recommendations that the father go into therapy, the children go into therapy, but the overall goal is to reunify the family.
So what do you do? What do you do with the first of all? What do you do with the care and protection case?
So,
Procedurally, you know what?
Continued. So they would have continued temporary custody with a review in 6 months.
Jim?
Well, I think after speaking with the Central Trauma Unit, the family has a lot of rehabilitative potential.
Okay.
And every effort should be made towards an eventual reunification of the family. I think under the service plan that refer the father to the parent to the treatment sexual offender program, and refer all 3 children to the sexual abuse trauma unit for a complete evaluation and treatment before that unification ever transpires.
Amanda?
I do agree that the father needs therapy, but also it's kind of confusing me because Alicia's not Lee's daughter, and Lee never adopted Alicia. So the rights there, I mean, to go back to her father, it should be her adopted father. And I'm concerned as to whether or not if Jason and Alicia stay together in whatever place they're placed in, are they going to continue that sexual activity with each other? Because it's like a learned behavior they did together.
Okay, that wasn't your position, but
He hasn't adopted her, but he has legal custody, it said?
I think he's in process.
yeah.
I think it said waiting on the paperwork, but it said had legal custody.
Right. And obviously he did because his wife had died.
Right, and her father had nothing to do
Nothing to
with
do with
her.
it, yeah.
Yeah.
Never
Yeah.
picture.
And that's Jason's father, too.
But I want to go back to, because we actually only have a few minutes to, Laura just said that she would agree to some kind of custodial situation, on stipulation. At that point, that Lee would then have to stipulate to the facts in the care protection matter. So if he's going to stipulate to the facts in the care protection matter, then he's also going to stipulate to the facts in the criminal case as well. And the district attorney would have to make some offer that's a little bit better than jail time.
Or perhaps it could be put on probation, or the case could be filed pending, a year of good behavior or 2 years or whatever that might be. It also doesn't talk in here either about if the goal is reunification, why not some sort of supervised visitation? So if the children are staying in the custody.
He is getting visitation, otherwise he would have been bringing an abuse of discretion motion. It's supervised visitation in DCF's offices.
Okay.
Yeah, he is getting visitation. So that's not an issue right now. Anybody have any final thoughts? Because what I'll do is because I want to discuss quickly what we're going to do on Thursday, but I'll take the first 15 minutes of Thursday to not only summarize this, but to tell you because something like this happened in the real case. And that's going to take more than 5 minutes for me to do. So I emailed you the what I call the IFA assignment, and we're going to use that as an exercise in class to kind of go through not only the medical neglect issues, but also it's funny because an MSL alum actually emailed me and called me the other day and said, somebody said I should call you because we don't know enough about administrative hearings, and he actually is in the process of appealing a fair hearing from the department to Superior Court, and he didn't know what to do because there's hardly anything out there. So I've given you the Cobble case. Read that really closely, because even though Cobble isn't medical neglect, is not a medical neglect case, It's the appeal of a parent who had been, whose 51A against him was substantiated by DCF. And so when we do this IFA case in class, we're doing the sort of the identical procedure, if you know what I mean. So that being said, you know, there are more of you than people for the roles, so
Maybe we can double up.
maybe you can double up, exactly. So what I have is somebody that's going to play the father, the mother, the school nurse, the DCF worker, the English teacher, and then I'm going to need, you know, somebody. I would be the hearing officer, but somebody can sort of help. I know what I'm going to do. Because we're probably also going to have time for some kind of legal argument as well. So let's do this. For probably half hour, we could do the agency hearing. And in the agency hearing, how about if, Jonathan, you play dad in the agency hearing? Is that okay?
Yeah, that's fine.
Okay.
But there's what, 9 roles and there's 12 of us?
Yeah, hold on, because I think I can figure this out. How about if, let's see, Jennifer, no, not Jennifer, Laura, your mom. Then the school nurse, Stephanie. Oh, you want to, okay, yeah, school nurse, Jen. Stephanie, the DCF worker. The English teacher, John. Now, we're going to, after this, we're going to take it to the next step, and that would have been when the Tumas actually appeal the agency decision. So that's when we're going to get into the Superior Court argument. So that's when we'll double up. So I'll have attorneys for the department, Amanda.
Department of Child and Family?
Yep, yeah. Amanda, Jim. Attorney for the parents, Nicole. Joe.
DCF attorneys.
Mike. Did I get everybody just now?
You forgot
The other Amanda. Okay, attorneys for the department, Amanda, and Jim. That work?
Yep.
And we keep our first rules, like I'm the mother in the first one, and then I'm the mother in the
Yeah,
appeal.
yeah,
Okay.
yeah. Okay?
I'll email Amanda today, and she'll
All right.
probably listen to the recording.
Attorney,
Attorney who?
are we not doing that part?
No.
The temporary custody? Okay.
So today we'll be doing the mediation exercise on the child sexual abuse case. So before we start, I'll be acting as the mediator. I'll introduce myself and then go around the room and just say your name and who you are, who you represent. And then I'll probably start with either the district attorneys of DCF to sort of summarize the case. And we'll kind of be going around and back and forth on whether we can achieve any kind of resolution for Lee and his children in both the care and protection case and the criminal case. Any questions before we start? Because it's going to get tricky.
I just have one question in general terms. So my role today is a guardian ad litem.
Yes, okay.
I-
And Jim is the court-appointed investigator.
I guess,
So you two
just
are
from
sort
my
of-
personal experience with guardian ad litem, was I thought that the guardian ad litem was pointed to represent children's best interests. But how is that different from an attorney that's representative of the children?
Good question, and we'll get to that. You were also assigned to read some role of counsel articles. And this is a perfect, this case had even more issues than I presented to you guys today. But this case actually represented that exact conflict. So if you want to hold off on discussion about that, I think it'll come up in the course of the discussion. If not, it'll come up when we'll talk about it when we discuss it afterwards. Okay? Amanda, you're all set. You can stay there. Yeah. We haven't started yet. And now we will. So I'm Paula Caldas, and I'm I've been asked by both the juvenile courts and the superior courts as well to conduct a mediation and see if we can, again, achieve any kind of resolution in the criminal case regarding, we'll just call him Lee, and the care and protection case of Lee's children. So first, let me just go around the room, and if you could all introduce yourselves and let me know who you represent.
Attorney Tess, attorney for Mr. Lee.
I'm sorry?
Attorney for Mr. Lee.
Okay.
Attorney Cannavale, representing Mr. Lee.
Okay, so two co-counsels for Lee.
Attorney Michael Beesman, guardian ad litem for the Lee children.
Okay.
Stephanie Tompkins, DCF attorney for protection of children.
DCF attorney John Tereshuk. Stephanie.
Okay, so co-counsel on for the department. We've got
Attorney Lowry for Jason Lee.
for Jason. Okay.
Nicole Grimes, district attorney for Commonwealth. Jennifer Rails, district attorney as well.
District attorneys. Okay.
Good afternoon, James Connie, investigator. I've been appointed to investigate the requirements of Chapter 119.
Okay.
Section 24.
Thank you.
Amanda Senate, counsel for the children, Alicia.
For the child
For the
Alicia.
child Alicia.
And I've been told actually Amanda Phillips, who represents Jonathan, is not here today. She did email me something, which if I have a chance, I'll pull up my email and read it to you if we come to that point. Let me have one of the department, either John or Stephanie, if you could just summarize how the care and protection case regarding these children got started.
Okay.
Either one of you.
Basically, the children have disclosed that they have been sexually abused by their stepfather, and the children report that.
When you say the children, who do you mean?
The Lee children.
All three Lee children?
No, there are 2 of 3 Lee children.
Okay.
The ages are 12 and 10.
Mm-hmm.
And the 12-year-old is Alicia, and Jason is the 10-year-old, under 10.
Well, he's just under 10.
Just under 10.
Okay.
And they have stated that their father had involved them in sexual activities, which were inappropriate for anyone under this particular age. And we are concerned about the care and protection of these children, and would like to maintain legal temporary custody and physical custody of these said children.
Okay. John, do you want to add anything for now?
Besides, I think she might have left out that Justin is the one who, the neighbor, was sexually abused by his stepfather, and this is how it got brought to the courts.
Let me hear from the district attorneys, Steve.
Well, we're here because Mr. Lee was sexually abusing his children. His wife died very unexpectedly in a car accident in November, and so the children cannot be placed with their mother. Right now, they're currently placed with family members, and we are seeking for the father to become incarcerated so that he's no longer a danger to his daughter.
Okay, hold on a second. How is it that Lee that the district attorney's office began the prosecution of Lee, began the investigation and ultimate prosecution?
We received a report from DCF.
You did? Okay, go ahead.
I thought we did.
That isn't how your case started. Jennifer, you want help?
I would say that.
You did ultimately receive that report, you're correct, regarding these children, but, go ahead.
We received the report and then
What
filed
report?
criminal charges off the report.
Who was the victim in the case that you're talking about?
The two children?
Justin,
Justin, who's Justin?
the neighborhood child.
Okay,
He
so,
delivers newspapers. He's a friend of Jonathan.
okay.
I mean, Jason, the son who was sexually abused by his father.
Okay, so looking at the record,
Okay, yeah.
what I've got in front of me and what you're telling me, this case actually started when Justin and his parents went to the police and indicated that Lee had been sexually assaulting Justin, correct?
Yes.
And then Lee was actually being arraigned in court on the particular day that your social workers went out to talk with the children, because the 51A had been called in, correct?
That is correct.
Okay, okay, just to get everything straight. And Lee is now also being indicted relative to his children as well, correct?
Yes.
Right.
Okay, all right, so we've got that.
Okay.
Let me have Jim, the court-appointed investigator regarding the camp protection case, just sort of summarize what your investigation consisted of, and maybe if you also have any recommendations.
Sure. I was notified on June 24th, 1987 to investigate this case. After the petition was presented to the court, and under Chapter 119, Section 24 of the Master General Laws, I submitted a report to the Honorable David Williams at the district court. This case is very.
So who did you talk to?
I talked to all the children involved, Alicia, who's age 12, Jason, who's 11. I spoke to the investigating social worker, as well as the police officer, and the doctor that examined
Okay.
and interviewed all those individuals.
And what did you learn?
Back initially, the care and protection case was filed by Officer Kathy Smith of the Andover Police Department on behalf of Jason, who's a neighbor, delivered papers, and Jason had.
Justin, you mean? You're talking about the neighbor now. Yep.
Justin had reported that he was sexually molested by Lee, and that he had witnessed Lee's two children also engaging in sexual activity and being sexually assaulted by, or inappropriately touched by their father.
Okay, and thus, on the day that Lee was arraigned, thus the 51B emergency investigation, the removal, and the initial temporary custody order of the court relative to the CP, right?
Yes.
Okay, and then?
And then Lee was initially interviewed by social services, and he kind of admitted to it. He didn't actually come right out and say that he did. He admitted that he had the children's take their clothes off on two separate occasions. One was around December, where he was doing it because they were arguing with each other, but he never actually admitted to touching them initially. Lee was eventually arrested and charged with sexual abuse with a neighborhood boy. The case was deferred to the DA, and the children have been placed with their paternal parents. Two of them are with their uncle. Alicia is with her uncle in Massachusetts. Jason is with his uncle, and Jonathan is with the paternal grandparent. Jonathan is 3 years old.
So you spoke with Kathy, the police officer, and Ellen, the social worker, who first interviewed the children at the home before they removed them?
I did.
Okay, and what did they say?
Initially, Jason was interviewed first, and he initially.
Are you sure?
Let me,
So they went to the home, and at the time, Lee was in court, so all 3 children were there, correct? The little one as well. Where was the little one?
Well, he was brought outside.
By who?
But by Alicia's sister. I thought the brother was interviewed first.
The brother was interviewed first.
Jason was interviewed first, but he refused to speak.
And so they interviewed.
So there wasn't an interview because he
Okay,
went
I
outside
apologize.
with Jonathan.
I apologize.
Okay, yeah.
Jason did not speak initially, and Alicia was interviewed.
Okay.
And during the course of the interview with Alicia, she disclosed that she...
And so at that point, I just want to get the scene straight. Jason had little Jonathan outside. Alicia was speaking to both the
Police
social
officer.
worker as well as the officer.
That's
Okay, okay.
Alicia, she talked openly about her relationship with her father. She expressed that she was not afraid of her father, but that what he was doing was wrong. That she was forced to have sexual intercourse with her mother, and at times her father would be lying next to them, Lee would be lying next to them naked, and at times he would touch them.
Okay.
At one point, they introduced the dolls
Okay. To Alicia.
To Alicia.
Okay.
And she demonstrated what was happening.
Okay.
Subsequently, Jason was brought back in for an interview. Lisa initially did remain, and he began to cry, and she had asked him to tell the truth.
Right, okay.
And I think at that point is, may I refresh my memory?
Of course.
Jason ultimately admitted that the molestation began around the time when he was 7 or 8 years old, and it continued. He said his father touched his stomach, and but his father had told him not to tell anybody who he would get in trouble. Never actually threatened him. Jason seems to have a real strong bond with his father, and was concerned about what was going to happen to his father, and the fact that he may not see his father again. So there were times during the interview, according to them, that it was difficult to get information from him concerning what had transpired.
So all of these statements came to you as a result of Ellen and Kathy telling you about their interview with the children, right?
Correct.
And then you spoke with the children themselves.
Yes, and that was,
What did the children say? Did they?
no, the children, I interviewed them together,
Mhm.
and they denied the statements that they had made. I actually read the statements to them,
Mhm.
and they both denied the statements, that they had made those statements. And they were emphatic, they were not afraid of their father.
So they denied that any sexual activity had occurred?
No, they said that they had taken their clothes off in front of him while he undressed.
And why was that? That's all right if you don't remember. What else did you have? So did you come to at least any sort of opinions or recommendations as a result of this initial report that you filed?
I did. I determined that the father was waiting trial for molestation of an able child, as well as the children. Even though the statements were inconsistent with me, there is evidence to support the molestation did happen. They also confirmed some of the statements when they talked to their Uncle Tony. They had told their Uncle Tony that their father hadn't made them undress, which I think lends credibility to the initial statements they had made to the police and the social worker, even though they had denied the statements initially made. The children emphasize that they're not afraid of their father. And in speaking with Lee, he is agreeable to therapy. And I think the ultimate goal here would be to reunite the family at some point, but now would be the appropriate time due to the fact that I think that the children need intense therapy as well as the father.
Let me hear from Lee's attorneys, either Jonathan or Joe, may start.
Well, our client.
So there were some statements that your client at least initially made to Ellen when he went to the DCF office, right?
Yeah, our client doesn't admit to abusing his children. He's suffered the loss of his wife, and
When was that?
Excuse me.
When was that?
It was.
Doesn't have to be day. I'm just wondering what.
It has to be 3 years ago.
What happened to her?
She died in a car accident.
Okay.
And so our client's been trying to maintain the cohesion in his house, and he's looking for help.
What did your client do?
He had to change professions.
He was in the Army
Yeah.
for some time, but due to a medical condition, diabetes, his vision started to fade, and as a result, he had to leave that position.
Okay.
Now he's in between. Is he teaching?
I'm sorry?
Is he teaching?
I don't know.
Assistant teaching. Assistant back in middle school.
Okay.
Back in middle school.
Let me ask, actually, let me hear from children's attorneys before I ask this question. Laura, you represent Jason. What's your position? Or
Yes,
what?
my client would like to be with his father as soon as possible. As this continues, the children, Alicia and Jason, were initially told they would be reunited with their father. And as this process continues, they become more and more anxious and speak less and less about the situation because they're protective of him and they really want to get back with him as soon as possible.
Okay. And Amanda, you represent Alicia?
I'm agreeing with somewhat what Laura had said. Alicia would like to stay with her father.
How old is Alicia?
Alicia is 13, just
Can
turned
you
13.
tell me anything about her?
She does very well in school. Her teachers had said everything nice about her. She's a good student, that they couldn't believe this would happen to her. Alicia initially had told the investigator what happened and then rescind what she said in fear of what was going to happen to her father. And now she's not saying too much to try and protect her father. But I agree that
From what I read of the investigator's report, and I haven't heard from Lee's counsel as to that, but allegedly there's some other story that Alicia and Jason and the dad are sticking to is allegedly what really happened. What is
yeah.
that?
So the story that Alicia and her brother are now saying is that they had an argument one day and the father didn't want argument going on in the house, because Jason had been getting undressed and Alicia walked in and saw him and an argument started to try and seize the argument. He thought it would be okay to just have both children undressed, so that way the argument couldn't happen. So now they're saying that the father had only asked them to undress in front of each other, which is vice versa what the original story had said, leaving out pieces.
Okay, so, Joe and Jonathan, I mean, is it your contention or part of the contention that the initial questioning of Alicia and Jason was improper in any way?
I don't think it was improper, but given the facts that our client explained what actually happened and the children have explained what actually happened, the deprivation of his children shouldn't be, the children should be returned to him at this point. Since the you know, we've canceled out the allegations. So the children should.
Joe?
The children's ability to remember and relate and recall their experiences could have potentially been undermined by the investigator. You know, as we know, Jonathan, his initial statement was that nothing was going on, and he was further pressed, and then Alicia got involved in
So
his.
further pressed, what does that mean?
Well, he wasn't further pressed by the investigator. He was pressed by his sister to tell the truth, and that we feel that they maybe should have been interviewed individually as opposed to together.
We'll get back to whether the interviewing techniques were faulty. What I'm concerned about, and the reason for the mediation here, is that it looks like there would be holes. I know that the department wants to take this case to, at least that's your position now, wants to take this case to trial, and you're looking for custody. District attorney is looking for, prosecution. No, there's no physical evidence, I see that here, no physical evidence of any kind of sexual assault on either of these children. So basically what we have in what looks to be the department's whole case and the Commonwealth's whole case is the out-of-court statements of the children, and that the crux of both of those cases appear to be, and I haven't heard from you, Michael, and I will when you can speak next. Ellen's statements of what the children told her on that first day, Ellen being the social worker, and then Kathy, the police officers, again, statements of what the children told her on that first day. And so it appears that there's going to be at least problems with standards of proof, although the standards of proof are, different in the care protection and the criminal case. But think about that for a moment, and let me hear from the GAL at least his position first before we go to those points.
Well, as the guardian ad litem, looking out for the children's best interest collectively, it's our position that they need protection from their father, that he is unfit, and that his, even if the full extent of the allegations are not proven, just the actual parenting choice itself of having the children be naked in front of each other, potentially naked, in front of him, and him in front of them, it just isn't very good parenting. And that should the criminal case show that not only did he abuse his own children, but the neighbor as well, that would also be further evidence that they're just not safe to be in this man's care. I mean, clearly the kids, according to their attorneys, love their father and want to be with their father, and perhaps that's their wishes, but that's not necessarily what's in their best interest. If they're in danger, I mean, essentially, their mother died recently, and Mr. Lee was the person that they could cling to help them through that emotional time. I mean, consent that they are very well-adjusted kids based on the trauma that they have experienced, but they're also perhaps being taken advantage of the vulnerability of that trauma, relying closely to their father and the love of their father, and now are perhaps changing their story to protect him because they don't want to see something bad happen to him, because essentially, who else do they have? Mom's gone, now dad's going to be gone. For the GAL position, it's more, even though they love their father, it's not in their best interest to be with him.
Thank you. Either the department or the district attorney can start this conversation, but as I mentioned before, what I'm concerned about is that it appears that the crooks of both cases are going to be out-of-court statements. So if you could, either one of you could start and summarize, the proof and the evidence that you have when you go to trial. And I'm not sure what the results of this discussion would be, but to me, it looks like that, maybe we can achieve some kind of stipulation and resolution of both cases, because, again, I'm concerned that if and when both go to trial, that there are going to be issues with the petitioner, DCF, and Commonwealth meeting their burden of proof. So who wants to go first?
Okay.
So it calls a DA. So tell me, okay, just imagine, fast forward to the trial. Who are you going to put on the stand? You said that your position, right now at least, is you're looking for prosecution and incarceration. So where's your evidence?
Well, our evidence as to how we can do this, or our evidence as to what the children have?
Your evidence. Your evidence.
Well, basically, the children are very young. They don't really know much about what happens, in a sexual relationship.
What's your evidence? Who are you going to put on the stand?
Alicia, she was able to point out things on the doll that most children.
Alicia's attorney is telling us that she's not going to testify.
Okay, well then Alicia's out-of-court statement would have to come in because.
How?
Well, under Chapter 233, Section.
She's not under 10.
She's not, okay.
We'll consider Jason's in a minute, and
Yeah.
we will talk about that. But since we started with Alicia, what if any of her statements could come in? Is there, if you look in the record, is there anything in quotes that she said that might be helpful?
She says yes. And she also stated that her father said, "Don't tell anyone or I'll be in trouble." So that's a quote from her.
What else
quoting
did
her
she
father.
say?
She said yes a lot when we asked her questions as to, did he do this, did he do that? She would say yes.
Because again, her statements are going to come in through Ellen or Kathy. So they would be, initially, it looks like they're out-of-court statements, offered in evidence to prove the truth of the matter asserted, that Lee sexually assaulted her.
Yep.
So is there any hearsay exception to any of her statements? Yes? Jen? I think Jim wants to help you, even though he's the investigator.
Oh.
Oh!
The first complaint?
What?
I'm sorry, what?
The first complaint?
What about her state of mind when she said it? Was that-
Well, okay, you mentioned two points that we'll discuss. Let's do the hearsay exceptions first, and then we'll come to first complaint. You said state of mind.
Yes.
Okay, so what case or cases can you rely on? So think about that for a moment. She's saying that Alicia's statements could come in for state of mind. What does Alicia's attorney say about that?
I'm sorry, say that again?
The district attorney, and actually, that would be the department's argument as well, is saying that the court would allow Alicia's statements to come in as a hearsay exception, that being state of mind, right?
Yeah. Just taking Alicia's position where, sticking to what she's saying in how she wants to be reunited with her father. I don't believe.
Okay, but you're not answering the question.
Okay.
Can Alicia's statements come in as a state of mind exception to the hearsay rule?
Absolutely.
Yeah, it can.
Absolutely.
Okay. And how could, Jonathan?
I would say no, because if she's not gonna testify, then.
Think of what hearsay is, and an exception to
No,
hearsay being state of mind.
I understand, but, they wouldn't be able to, if it has to come in through Ellen, and I forget the other.
Right.
situation, They wouldn't be able to lay the foundation that it was her present, it's a present state of mind, her present state of mind. She would have to testify to say that it was how she was feeling, or that was her state of mind. They can't speculate what her state of mind was.
To help you a little bit, what does the Jennifer case say? And that, actually, that would be more pertinent for the care and protection trial than the criminal trial. The Jennifer case, Laura tells us about state of mind and whether and how it can be used in a care and protection case.
So it can come in, relying on Jennifer, can come in for the state of mind exception, but you need more evidence. It has to be clear and convincing to demonstrate the parent's unfitness.
Okay, so wait a minute. You said it could come in for the state of mind exception. So how is state of mind, and I can't find my summary of it, that's all right. How is state of mind pertinent in a care and protection case?
What the child was thinking at the time the statements were made. So not for the truth of the matter, to whether there was sexual abuse or not, but to what the child was thinking.
So if I'm following you so far, John and Stephanie as department attorneys would be seeking to have, and whoever, either Ellen or Kathy, are on the stand, and they're beginning to say when they're on the stand, right, Alicia said blah, blah, blah. Lee's counsel, Alicia's counsel would be on their feet objecting, right? And they'd object because they'd be saying that's hearsay. The department's attorneys would then offer proof, on their offer of proof, would be arguing to the judge that, no, Your Honor, we're not introducing her statements to prove that Lee actually sexually assaulted her. We're just introducing her statements to show what her state of mind was at the time. And so, yes, they would come in, but just for state of mind. So what? Big deal, state of mind. It's not enough. So what else do you have? Let's go back to her statements again. They come, go ahead. Jennifer.
According to Jennifer's case, the statements can go through the experts, which would be the two social workers that went to talk to them originally.
Yeah, again, but think of the purpose for why they're coming in. They could only come in for state of mind. They can't come in to prove that it actually happened, right? And that's one of the holes, one of the problems with, in this case, the burden of proof. What's the Commonwealth's burden of proof, by the way? It's a criminal case.
Unreasonable doubt.
Yeah, that Lee assaulted his children, in whatever the charges are, rape, indecent assault, and battery, child under 14, blah, 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 blah. They have to prove the elements of those crimes beyond a reasonable doubt. What do you guys have to prove, the department?
That he's unfit as a parent.
Yeah, and what's the standard of proof?
Parent experience.
Yeah, and why and how is he unfit? Because he
subject these children to danger and the sexual abuse itself, and he also was he lacked appropriate parental judgment.
right. Okay. So far we have Alicia's statements, maybe, and they're coming in, but just for state of mind. Any other way Alicia's, let's stick with Alicia for a moment. Any other way Alicia's statements can come in? Anyone can answer that. The department, the Commonwealth, Lee's attorneys as well, if you want to weigh in on the weight of the,
How
well,
the statements come in?
in order for us, again, to sort of come together, you know, what do we have for a case here? If what you have is very little, then let's talk about some sort of settlement, right? How else can Alicia's statements come in under a hearsay exception? So she said at one point, I hate him. He's a child molester. Yeah,
She says, I
Can-
don't want to see him again.
right.
And also there was the emotion behind it, which in a case of something being real, it was real to her. And so the emotion behind it sort of justifies it really for it to be a fact that it did happen in her life.
Okay, so there's another possibility. Now, Jim before raised the option of either of the two initial investigators testifying relative to the first complaint doctrine. What do you guys think about that? So in DCF's case, that you put, you know, say, Ellen on the stand, or Kathy, the police officer, on the stand. And they, again, either one of them starts to say, well, Alicia told me, blah, blah, blah. Oh, no, hearsay, objection. No, Your Honor, it's not hearsay. The purpose for which this witness will be testifying is as a first complaint witness. What's wrong with that? Is that feasible? And again, we're gonna summarize afterwards all of the evidence and weigh whether that's enough. Joe?
I thought
What's the
that
go ahead.
No, I thought that I read that wouldn't be feasible because it would be prejudicial, it would just be repetitive. Or talking about if it was only that
Yeah,
person
oh,
testifying?
yeah,
Oh, okay. I
so
thought-
either
I thought
one
it
of
was
them
in
is
addition.
allowed as the first complaint
Okay.
witness.
I thought it was in addition.
Laura?
In Massachusetts, under Article 12, doesn't it require face-to-face? So that while there is first complaint, it's not applicable in Massachusetts?
Yes, it is. This is the Commonwealth versus King case, which is still the law in Massachusetts. And the Aviles case that was decided, I think it was the last case you guys read.
Yeah. Yeah.
Very recently. So I know what you're saying about face-to-face, and that's another issue, okay? But there is a problem with the first complaint witness.
There's no foundation.
Well, it's not no foundation. You told me before that your client wasn't gonna testify, all right? According to both the department and the prosecution, these people are the victims. So if you have either the officer or the worker attempting to testify, first complaint, again, it's not that testimony isn't coming in for the truth of the matter, right? You're saying it's not hearsay, that the only reason a first complaint witness is testifying because that person is corroborating what the victim would be testifying about, and what the victim would be testifying about would be, you know, the alleged actual truth of the crime, of the rape, etc. But again, the problem is that
prejudicial.
both counsel for Alicia and Jason are saying they're not going to testify. So there's an issue with that, whether the judge is going to allow Ellen or Kathy to be testifying as a first complaint witness when there's going to be, again, no victim testifying as to that complaint. You see where the hole is? Because that's the whole purpose of first complaint, that you have the victim testifying and then you have the person to which that victim first complained to.
To
Right,
back up
yeah.
and support their testimony and.
Yes, exactly. So we have some holes relative to Alicia. And we'll come back to it if you could think of anything else. But let's jump to Jason, because Jason, at least appears on its face that there's this statutory exception.
Can I
Yeah.
clarify one thing?
Yeah.
Is Justin also refusing to testify?
Oh, there's a problem with Justin. He and his parents have actually moved out of the jurisdiction. The Commonwealth has been forced to now cross his case. The Commonwealth is going forward regarding these children. So now the Commonwealth has no witness that could possibly have even testified in the parent protection case. And that's the reason for trying to come together and figure out some sort of resolution here, especially where it looked like there was some positives about this family. I heard from Alicia's attorney, and the report indicates it as well. Alicia and Jason, very mature, smart kids who either have recanted the actual truth of the event, or there's some confusion, and that's why I initially asked, does anybody have any problems with the leading type of questioning that the initial investigators conducted? At least on a reading of what I have before me, other than the statement to Alicia, do you know why we're here?
Well, they specifically told them, right? I mean, I didn't say anything because I thought these guys were.
No, that could be your position
But
as
basically-
GAL, so tell me about it.
You know, when the police came, it said in their report, we had informed Jason and Alicia of the reason for their father's arrest, which they had witnessed. So, you know, that's a traumatic experience for the children to begin with, seeing their father arrested. And then on top of that, they tell them, your father was arrested because he raped your neighbor, you know, your friend. So, I mean, that could be leading to the kids to create
So
some
is it,
sort of story of what happened.
is it possible that and I'll just call it the second story, right, is actually the truth, and I'm gonna let Laura consider that since she represents Jason, the kid in the middle. So that if you combine the faulty leading questioning of the children with the trauma of knowing that dad is, you know, going to court now for supposedly, you know, raping their friend. If you taking that all together, you know, what kinds of holes in this case can you come up with? Before we consider the statute, is there anything in your position that you'd like to say?
So I have one that doesn't support my position as the attorney. His first interview was very explicit, and well, I don't know because it's not my official role as the attorney, but his first interview to Ellen was very explicit and doesn't seem to tie.
But that wasn't my question, okay? My question dealt with, and I think we can all agree that, you know, looking at what we have, that there was some problems with the questioning of these children. Whether they in fact had been indeed, you know, raped or assaulted by their dad. There were problems in the sense that they didn't really get to tell their story. The story was, you know, in the form of the questions, if you know what I'm saying. So.
Well, one of the things was when they left the house that first day, the policeman came in and said, you need to leave now. He's been let out without bail. Alicia, go pack some clothes, and they grabbed the kids and ran out the door. I mean, that only added to the stress of this situation.
All right, let's come back to we'll come back to this. The statute. So it looks like, Laura, the department would be seeking to introduce Jason's statements under 233-83. The Commonwealth would be seeking to introduce Jason's statements under 233-81.
Right.
Do you have any argument against them being able to come in?
So I think under Colin that it can come in for the care and protection case.
But so what are the standards for the care, for the department to get those statements under 83?
That under, do I want to say Rebecca? No, I'm sorry, it's Rebecca. The standard is very low, that if the child is unavailable, generally the out-of-court statement can come in under Section 83.
So let me ask either you or the department, John or Stephanie, how is Alicia, or I'm sorry, how is Jason unavailable? What makes him unavailable?
He's under 10.
That doesn't make him unavailable.
His unavailability, well, the lawyer has already said that he will not be available for testimony, but.
Why?
She didn't explain why.
He's traumatized with that.
So the unavailability goes to his inability to actually be in the courtroom and talk about it, and I'm assuming that there might be some expert or other, to support the fact that he, okay. So if he is indeed unavailable under that piece of it, is that all you have to show as the department to get in his statements?
Actually.
What do you have to convince the judge about?
It's that combined with the age that he is, and he gave explicit details as to the nature of what happened originally. And with those statements alone, because of his age and his unavailability due to his being traumatized about the events, he wasn't initially forthright with the information, but had a breakdown, emotional breakdown, describing the acts. And someone of his nature, of his age, would not necessarily have access to the description that he had with the details of what his father made him do.
Michael had his hand up while you were talking.
Yeah, I
I
was
don't know
just
if you
gonna
wanted
help
to
out
add to
it,
that.
but also the person that he made the statement to is available to testify.
Yeah, and that would be
that-
Eleanor.
And that
Kathy.
the testimony is more probative to the evidence than any other evidence. There is no other
That's all
evidence.
they've got
That's all we have,
for
so.
Jason.
And one of the other things I was gonna say, when you were talking about why Jason would be unavailable, I think there's really two opposite reasons why. It would seem to me it'd be more the GAL's position that.
So what's your position?
That it would be traumatizing to the children to have to testify against their father. They love him, they don't wanna harm him,
Right.
etc. But it's more Jason's position, I think, that he just doesn't want to. I mean, he doesn't wanna get his father in trouble, and maybe he doesn't wanna say what did happen.
Mm-hmm.
And he originally proved that when they originally questioned him the first time, and he didn't disclose.
Good.
But then when his sister said, "Tell the truth," then he had the emotional breakdown where he told exactly what happened and gave specific details.
So Laura, it appears that you, and tell me if you think otherwise, you'd almost have to acknowledge that they're probably gonna come in, at least in the care and protection case.
Yes.
Okay.
Yeah.
Do you have issues with the statements coming in the criminal case?
They-
And Lee's attorneys should weigh in on this one too, on the criminal, statutory exception, the 23381.
So under the criminal, the 81, he would still be unavailable in the other criteria prior notice to defendant, which they could do, but the reliability, I think, is questionable because the story has changed. They're corroborating evidence, there isn't any. And then on a separate hearing, they must show by more than a preponderance of the evidence the reason why the hearsay should come in. So I think that, at least two of these elements can't be satisfied. So I don't think that it'll come in under 81.
So that's Jason's attorney's position. What about Lee's?
We agree that the statements shouldn't come in because of the lack of reliability of the statement, like my sister counsel
So
stated.
what is reliability? What would make them reliable?
Well, if they weren't leading, if the questions weren't leading, and if he didn't initially, he essentially has 3 inconsistent statements.
Okay, okay.
So it wouldn't be reliable, and so as such, it shouldn't be, this statement shouldn't come in under
381. Okay. What about the Commonwealth? Obviously, you want them to come in. Do you think that you'll be able to get them in the Superior Court?
Yes, I do.
Yeah.
Because it clearly states in the law that a child under the age of 10, which is what Jason is, it can come in. It says, an out-of-court statement of a child under the age of 10 describing an act of sexual contact performed on or with the child, the circumstances under which it occurred, or who identifies the perpetrator shall be admissible as substance evidence in any criminal proceeding. So there would be no problem with us getting it in from Jason.
Okay, but you didn't read further the other requirements that
Oh, well, okay.
So what about reliability? And that seems to be the problem here. How will you convince the judge at the 23381 hearing that the statements would be reliable? Jen?
Well, it was the same statement that the sisters made. They both have the same story. So I feel like that would be reliable on its own. You can't get the sister statements in. At least the fact that both their stories are the same from the father and such that they should be able to come in.
What about the circumstances under which they were made? Are the circumstances reliable?
The circumstances, one could argue they were a little bit coerced. The children were placed together. Jason kept saying that nothing happened, and Alicia told him to tell him the truth. She pretty much demanded an answer out of him. However, he was not in the room when she said everything. So their stories were pretty much identical. So how can that happen if you have 2 children that were not in the same room? Alicia gave her testimony to the police officer and the social worker before Jason was put in the room. However, the questioning was also, did he touch you here? Yes. Did he touch you there? Yes. So it kind of also put ideas in her head as to what really happened. So it could have actually coerced her into making statements that she really shouldn't have made. You know what I mean? So it kind of works against us in a way, the way that the questioning was happening, because it was, in my opinion, it was coerced. And I don't know if that's necessarily the district attorney office's opinion, but in my opinion, it was coerced, and therefore it would be a really hard argument to make that it wasn't.
I do think it was coerced, but I also feel like the fact that she was given the doll and was asked to show, how is he touching you here, should also be taken into consideration.
The anatomical doll.
Right.
Okay. Stephanie had her hand, and then Michael too.
I was just going to say, as related to Jason's statements, he had specific and explicit details about what his father made him do. For example, sucking his father's penis, and also, and these are not coerced questions, these are statements from Jason's own words, and he described him having to sit on his father's stomach naked, backwards. Those are adult moves that I would disagree that Jason would have access to, knowing how to do it without an adult assistance of telling them. That's not, it's learned behavior, as opposed to just ordinary imaginations of a 10-year-old or less than 10-year-old.
Mm-hmm.
So although there may have been some inconsistencies with stories, what is remaining reliable is that he was able to describe this has happened to him since he was 7 or 8. So this has been an ongoing events that occurred between he and his father, and even if it is unrelated to his sister Alicia being involved, he described his own behaviors, which were not coerced.
Okay, and then Michael?
Well, I would argue, on the reliability part, it basically says that after holding a separate hearing and where practicable and were not inconsistent with the best interest of the child, meeting with the child, that such statement was made under circumstances inherently demonstrating a special guarantee of
Right.
reliability. When the kids made these statements, they were seeking help for their father. You know, I mean, as consented to by their own attorneys, they wanted to get their father help, and they want the family to get back together and for their father to get the help that he needs so that they can have a happy, loving family. So, you know, they weren't making these statements to get the father in trouble. They were making the statements to get the father help that they feel he needed. So now that, as was stated by the children's attorney, you know, they were under the impression that there was going to be a reunification of the family. Now they feel that there's not. Now the story's changing. So, you know, it's again the child trying to fix the problem of, well, you know, I said that he did these things before thinking he was going to get help, but now they're saying we're going to use that against him to keep him away from you, so I'm going to say he didn't really do these things. It would seem to me that the earlier statements when they were seeking help from their father
Were more
and for their
reliable,
family
is that
was
what you're
more
saying?
reliable than after the fact when they now feel like we may never see Dad again if we say that he did these things.
And that leads to another point, is GAL, what, if anything, do you know about recantation?
As far as in general, like in terms?
Yes.
Oh, well, I mean, these type of abuses can often happen in patterns. So, you know, you may have periods where initially things might be better, and then, you know, you may see the pattern of abuse start again. It could also go on to further generations. So, you know, the children, if they have been abused by Mr. Lee, they may abuse their younger brother. They may have used
Are you talking about the cycle? I'm sorry, that's
Okay, so
an
we
interesting
can't-
point. That isn't what I meant, though.
Oh.
What I meant was, in terms of what you were saying, that the initial statements were more reliable.
Oh, it happens
Isn't there a
very
general
often. Yeah, I mean,
consensus
it's
that
common for the children to recant on
for
their
children in
statement.
general, in these kinds of cases, to recant?
Right.
And it is
And
more
that's
common.
that's in the report of the court investigator, that
Did you say that?
typical of sexually abused children, although the children retracted most of their statements, typical of sexually abused children, when a reporter interviewed them, they did not, they did say they were made to be naked together with their father, who was also naked.
Which is the second story. And so that's the recanting, if
But
we
it
were to
is-
believe the first story.
That is common for
But
them to change their story after the fact.
to recant.
And being the nature that we see so many children have similar cases, we see children recant the story for the protection and want to, for the reunification, to be back with their parents, regardless of whether the assault happened, the sexual abuse occurred. Children don't want to necessarily be separated from their parents,
Right.
because that's their parent that they are familiar with. So that's very common. But it doesn't make it right.
So I'm assuming that, and I'm asking this of Lee's attorneys, is your client intending to take the stand in either of the cases? No. So here's the problem. Of course, it can't be held against him in the criminal case, but can it be held against him in the care and protection case?
If he doesn't testify,
Right.
it can be.
It can be, in the care and protection case. So the court could draw an inference of unfitness if your client does not testify in the care and protection case. And so just to summarize here, okay, it looks like the department's case would be introducing Jason's statements under 233-83, and possibly they're going to come in. Alicia's statements are only going to come in for a state of mind or excited utterance, but they're not going to come in for truth. Court, again, what I just said, can draw the inference of unfitness. The investigator's going to testify, and the investigator's going to submit his report. Of course, it is all hearsay, but it's allowable. So the court, you know, again, can rely on what the investigator has come up with. Anything else? Care protection case?
At the very least, he did not act appropriately as a parent to what he did admit, which was taking
Okay, but I'm summarizing the evidence,
Oh,
not
evidence.
your position.
Oh, okay.
And guess, I didn't, because Jonathan's attorney wasn't here, we haven't mentioned Jonathan at all. So supposing that Jonathan not only being the youngest, but not part of the alleged abuse, it still could be Jonathan's attorney's, it could be Jonathan's attorney's position that, like the GAL, possibly, that were Jonathan, you know, old enough and mature enough to make a decision, Jonathan might want to be free from the abuse of his dad. Or Jonathan's attorney might draw a different position, that being that there are no allegations regarding him at all, that the father was, you know, again, that would mean that father's always been appropriate with Jonathan. So again, I'm not sure what her position is.
I think she mentioned something the other day about Jonathan being taken away for care and protection, and she stated a case that said something like, the judge said to stop a disaster from happening. You know, where Jonathan would get older, it, you know, could potentially happen to him too.
Okay, so she would be using her judgment, her substitute judgment approach to want to be free from Lee's abuse. Okay, all right. So that would be the department's case. You know, Commonwealth is and the department's case, obviously, there's a problem with all of that. Will it amount to clear and convincing evidence of unfitness? Commonwealth has an even more difficult time. The 233-81 has, as you guys have discussed, more requirements than 83. So that could be an either or. And so, but even if Jason's statements come in, you have really very little else. You do. The court-appointed investigator has no role in the criminal case at all. And again, Alicia's statements may come in, but again, not for the truth, but for any of the hearsay exceptions. So, does anyone have want to lay anything on the table of something that could be a resolution that would satisfy, I guess, everyone in the care and protection case and or the criminal case? Obviously, you know, he doesn't want to go to jail, so.
Is this still as the district attorney, or is this?
As the district attorney,
Oh,
yeah.
well, then I can't see my jail.
No. Laura?
I would say to follow the actual investigator's recommendations that the father go into therapy, the children go into therapy, but the overall goal is to reunify the family.
So what do you do? What do you do with the first of all, what do you do with the care and protection case?
So,
Procedurally, you know, what?
Continued, so they would have continued temporary custody with a review in 6 months.
Jim?
Well, I think, speaking with the Central Trauma Unit, the family has a lot of rehabilitative potential.
Okay.
And every effort should be made towards an eventual communication of the family. I think under the service parameter, that, you know, refer the parent, the father to the parent, I think, to the treatment, sexual offender program, and refer all 3 children to the Central Abuse Trauma Unit for complete evaluation and treatment before they have a unification.
I do agree that the father needs therapy, but also it's kind of confusing me because Alicia's not Lee's daughter, and Lee never adopted Alicia. So the rights there, I mean, to go back to her father, you know, it should be her adopted father. And I'm concerned as to whether or not if Jason and Alicia stay together in whatever place they're placed in, you know, are they gonna continue that sexual activity with each other? Because it's like a learned behavior they did together.
Okay, that wasn't your position, but.
Lee he hasn't adopted her, but he has legal custody, it said?
I think he's in process.
Yeah.
I think it said, waiting on the paperwork, but it said had legal custody.
Right. And obviously he did because his wife had died.
Right, and her father
Yeah.
had nothing to do
Nothing to
with
do with
it.
it, yeah.
Yeah,
Never.
yeah.
And that's Jason's father too.
But I want to go back to, because we actually only have a few minutes to, Laura just said that she would agree to some kind of custodial situation, a stipulation. At that point, the Lee would then have to stipulate to the facts in the care protection matter. So if he's going to stipulate to the facts in the care protection matter, then he's also going to stipulate to the facts in the criminal case as well. And the district attorney would have to make some offer that's a little bit better than jail time.
Or perhaps it could be put on probation, or the case could be filed pending,
Mhm.
A year of good behavior or 2 years or whatever that might be.
Mhm.
It also doesn't talk in here either about if the goal is reunification, why not some sort of supervised visitation? So if the children are staying in the custody.
He is getting visitation, otherwise he would have been bringing an abuse of discretion motion. It's supervised visitation in DCF's offices.
Okay.
Yeah, he is getting visitation, so that's not an issue right now. Anybody have any final thoughts? Because what I'll do is because I want to discuss quickly what we're gonna do on Thursday, but I'll take the first 15 minutes of Thursday to not only summarize this, but to tell you because something like this happened in the real case. And that's gonna take more than 5 minutes for me to do. So I emailed you the, what I call the IFA assignment, and we're gonna use that as an exercise in class to kind of go through not only the medical neglect issues, but also it's funny because an MSL alum actually emailed me and called me the other day and said, somebody said I should call you because we don't know enough about administrative hearings. And he actually is in the process of appealing a fair hearing from the department to Superior Court. And he didn't know what to do because there's hardly anything out there. So I've given you the Cobble case. Read that really closely because even though Cobble isn't medical neglect, it's not a medical neglect case. It's the appeal of a parent who had been, whose 51A against him was substantiated by DCF. And so when we do this IFA case in class, we're doing the sort of the identical procedure, if you know what I mean. So that being said, there are more of you than people for the roles, so.
Maybe we can double up.
Maybe you can double up, exactly. So what I have is somebody that's gonna play the father, the mother, the school nurse, the DCF worker, the English teacher, and then I'm gonna need, somebody, I would be the hearing officer, but somebody can sort of help. I know what I'm gonna do. because we're probably also gonna have time for some kind of legal argument as well. So let's do this. For probably half hour, we could do the agency hearing. And in the agency hearing, how about if, Jonathan, you play dad in the agency hearing? Is that okay?
Yeah, that's fine.
But there's what, 9 rows and there's 12 of us?
Yeah, hold on, because I think I can figure this out. How about if, let's see, Jennifer, no, not Jennifer, Laura, your mom. Then the school nurse, Stephanie. Oh, you want to, okay, yeah, school nurse, Jen. Stephanie, the DCF worker. The English teacher, John. Now, we're gonna, after this, we're going to take it to the next step, and that would have been when the Tumas actually appeal the agency decision. So that's when we're gonna get into the Superior Court argument. So that's when we'll double up. So I'll have attorneys for the department, Amanda.
Department of Child and Family?
Yep, yep. Amanda, Jim, attorney for the parents, Nicole, Joe,
DC.
Mike. Did I get everybody just now?
You forgot
The other Amanda, okay, attorneys for the department, Amanda, and Jim. That work?
Yep. And we keep our first roles, like I'm the mother in the first one, and then I'm the mother in the appeal.
Yeah.
Okay.
Okay.
I'll email them in today, and she'll
All right.
probably listen to the memo, the recording.
Thank you.
Who's gonna be attorney for Jamil?
She heard you volunteering.
Are we not doing that part?
No.
The Deborah Custody? Okay.